All right. So William Ha is a California estate planning attorney who uses his social media platforms and growing audience to educate his followers on the importance and intricacies of having an estate plan. He also often hosts local gatherings to help people get the process started and answers the countless questions that tend to come with the topic. William, thank you so much for being on the Dying to Know More podcast. It's so nice to have you here.
Thank you so much for having me, Ashley. Good to be here.
Okay. Good. Well, we're just going to dive in with some kind of basic questions, basic but important questions before we get into some nitty gritty. So, first and foremost, who needs an estate plan and when should they get it done?
So, I think the vast majority of Americans, if they have things to lose, or if they've suffered some personal loss, I think those people are people who should get estate plans. I think if I had to do like a bright line, it's people who happen to have real property, like a house, and also minor kids. When you happen to have minor kids and you pass away, there are things in the law that makes it really difficult for the kids if there's no plan in place. So I think that's the main bright line rule when it comes to who needs estate planning more than not.
So, what's an example of something in the law that would make it difficult if somebody had kids but no estate plan?
Absolutely. So when you're a minor, which means when you're under 18,
Hmm.
you can't really hold assets outright in your personal name. So let's say, for example, your parents didn't have that much money, but they had enough to pass on to their kids. Um, so if it's like 200 grand or something like that, the kids themselves cannot hold that money. There has to be some sort of guardian that's appointed by the court that holds money on their behalf. So if you don't have those people kind of ready in line through an estate plan, then the court basically got to hash that out for them. The other
Okay.
thing is their custody and also their guardianship, as in like their parentage.
Hmm.
So if you have different types of family members who would want to, fight or petition the court to basically take over um, as legal guardians, that could end up being like a really long drawn out process if there was no planning done like for them.
What would happen to the kids? I mean, would they go into state custody or?
Yeah, I mean that's absolutely a possibility. Sometimes they might be under they might be held under like a temporary guardianship until
Okay.
the court really determine who is best suited to take care of the kids. So let's say hypothetically, if parents were in a plane crash and kids are at home, then maybe they'd go with a family member if there is any nearby until they figure out who should really be the legal guardians. If it happens to be like a mixed marriage where you have a blended family where you have different parents, different sets of parents,
Yeah.
I feel like that's probably when the issues really crop up and it becomes really difficult.
Okay.
Yeah.
So a lot of people think that a will is the same thing as an estate plan, or if they have a will that they're covered. Are they the same? Are they different? If so, what's the difference? And do you need
Yeah.
both?
So I want to say that is an estate plan is more like the umbrella term.
Okay.
Estate planning is just like thinking about what to do about all that stuff. I mean, so estate planning would encompass like advanced healthcare directives, powers of attorneys, trusts, wills, etc.
Okay.
So let's start from the basics. A will is basically a document that you submit in probate court that allows you to override what the state would have done by default. So the
Okay.
adage is that if you don't plan, then the state already has a plan for you. The
Okay.
state's plan is something called an intestacy, the rule of
Okay.
intestacy, which simply means you've died without a will, you've died intestate. That basically then determines where your assets should go. So
Okay.
let's say you have a 50-year-old woman who doesn't have a spouse, but she happens to have two kids. When she passes, then it goes to her kids 50-50.
Okay.
That's one hypothetical simple one, right? Let's say, for example, the year before she passed, she marries someone 20 years her junior. She still happens to have two adult kids.
Yeah.
All of a sudden, in the state of California, the kids are now suddenly a co-heir with this brand new spouse. So now the estate split one third, 33%, or one
Okay.
third, one third, one third. Um, let's say, for example, she doesn't want to give anything to her kids at all, or she wants to give everything to this new spouse. What she could do is she could have a will, and that would override that rule of intestacy so that her assets could then go to the spouse, or if she wants to only give it to the two kids, or if she wants to give it to some random charity, she actually can as well. So a
Okay.
will allows people to override the default rules of intestacy.
Okay.
Another thing that a will could do is they could also nominate guardians for minor children in the
Okay.
will itself. And another important thing that a will could do is basically waive the requirement of a bond to serve as executor if it does end up going into probate. So in California, I don't know if it's like this for many other states, but typically when there's real property involved, you might have to put up bond to serve as an executor. And the executor is just a person who's kind of like the quarterback or the chief that kind of interfaces with the court when it comes to the estate.
Right.
So that's what a will is.
Okay.
Um, and a will is for the probate court. People in the past, I don't know, I'd say 50 years, it's gotten really popular to use a trust to avoid the probate process.
Yes.
And how a trust works is it's basically a legal contract, a legal agreement between yourself, along with the potential successor trustee who takes over
Okay.
upon your death, and basically, and that person then has duties to the beneficiaries, which might be the kids. And once you've got the trust sort of drafted up and executed, you then transfer your assets to be held in trust, so that
Okay.
when you pass away, you own nothing in your personal name. Because you own nothing in your personal name when you die, there's nothing to probate. Everything you just kind of handled through the trust, so it like basically survives you at that point. So I'd say within the past 50 years, the trust has been a really popular way to avoiding probate.
Okay.
So that's
So
kind of how the trust fits
why
in.
do people like probate always sounds like such a bad word. Like everybody wants to
Right.
avoid probate. Why is that? Is it just
Yeah.
because
So
it's so yeah,
yeah.
like why?
So I mean, it's not all bad everywhere. It depends on how many like what your assets are too, and what state you're living in.
Okay.
So in general, for most people, I would say that probate is bad because it's slow, as in like it's about a year and a half to 2 years slow. It's expensive. The probate attorney in California is automatically guaranteed a certain amount of money in probate fees. That's based off of a scaling percentage of the estate size.
Hmm.
The personal representative, that's the person who will be like doing the tasks. They'll also be like paid a certain amount as well. And also everything is public, meaning everybody will know the assets involved, everybody will know who the beneficiaries are, what they're owed eventually. So it's not that easy because you actually have to pay the court to get these records, like $5 here, $2 here. But you can actually go to the court physically or online to look up these documents. You can see what the will said. You can see people's phone numbers, addresses. Every single time I file a probate for a client, they're contacted by all sorts of people, solicitors, trying to get their business to sell the house or to lend money to. So it's fairly intrusive. So I think like the bottom line is that probate is expensive, slow, and public. But I think from my perspective, I think if a probate is fairly straightforward, um, it's not so bad. But then again, for the client, maybe it's not ideal. So if someone, say for example, had a business and they passed away suddenly, and then all of a sudden the business ends up in probate, that's when it's such a mess because it's just a brand new entity that the person representative has to figure out how to basically handle
Right.
in probate. So it really depends on the situation, but I think the vast majority of Americans, if they had a choice, they would try to avoid probate.
So if somebody has already has a will, um, example, my aging parents have a will. Would it make
Mhm.
more sense to, can you just transfer it into a trust? Is that an easy thing to do? Or is that, I mean, obviously you'd have to work with somebody like yourself, right?
Yeah, so a will and a trust is not mutually exclusive.
Okay.
People who do estate planning have both things.
Okay.
Um, so the reason why this is because it's because even though you have the trust, there's still a likelihood of ending up in probate anyway. And the reason
Okay.
why this is because sometimes people, even though they have the trust, they may have forgotten to transfer assets held into the trust.
Okay.
So a classic example for a lot of people is they make the trust, They put the house in the trust, and then they do a refinance 10 years later. The bank says, okay, we'll give you the money, we'll refinance the house, but you need to take the house out of the trust, put it back into your personal name, sign under your personal name, and then we'll give you the loan for the refinance. Oftentimes, people forget to put the house back into the trust through the title.
Okay.
And when they pass away, they own it personally in their personal names, as in like Will Ha personally, as opposed to Will Ha, trustee of the Will Ha Revocable Living Trust.
Okay.
Um, that house ends up in probate. So if it does end up in probate, there's something called they do also, then the probate court is just going to rely on the will. And for people who've done estate planning, the will functions as something called a pour over will, which basically says if I happen to have any assets left outside of trust, I want you, the personal administrator, the personal representative, to put it back into the trust. So even though you're in probate, at the very least, it's going to be put back into the trust. So if let's say, for example, if your parents had a will already and they happen to have assets that might be in danger of getting in the probate and they don't want that, they
Hmm.
could have a trust as well, but it doesn't mean that they dispose of the will at all, because the will is
Yeah.
kind of a fairly unique document. A person can only have one will, at least one valid will,
Right.
whereas people could have like many trusts. And the best way to think
Okay.
about a trust is just a way to hold an asset as opposed to some sort of like unique document where one person only has one.
Gotcha. Gotcha. Okay. My just personal note. My grandmother had a lot, like mineral rights in oil wells, and I'm trying to help
Hmm.
my mom get them transferred into her name right now. And one
Yeah,
of the things I've learned along the way is that it would probably make more sense to just put it in a trust
yeah,
because, as every generation dies off, to go through this nightmare experience of chasing down documents and submitting them, and all that, it's been quite the experience. So I'm
right. And
kind
I
of,
think, yeah, for a lot of people, I don't think something has to trigger someone to think that this is even a good idea. I mean, I think
yeah.
which is kind of why I feel like, even though I market my services to people who are either my age or slightly a little older, I feel
Hmm.
like the vast majority of my clients are still in their 60s, 70s, and 80s, because there's something in their lives that kind of triggered them to get estate planning done.
Yeah.
You know,
How often do you recommend people kind of revisit either their will or their estate plan, or any of their plans?
I want to say 5 years, 3 to 5, maybe 5 to 10 years or something like that would be okay.
Okay.
So a clear example is, gosh, I mean, it's so funny because I was talking to Lisa Paul last week, and she said, "Gosh, what you do is so boring." I'm like, "Gosh, to me it's not too boring, but I'm about to dive into a subject that's fairly boring, and that's taxes." So,
Okay.
oftentimes I'd say every 10 years or so, there
Hmm.
might be some sort of weird, crazy law that changes in tax,
Hmm.
where like it kind of like makes people have to redo certain things, otherwise, like the allocation of the taxes, it ends up being bad. So, for example, back in the 90s, the something called the federal estate tax exception was fairly low, meaning if you happen to have like a certain amount of money, um, and if you have over that threshold, you'll be taxed at a really high rate,
Hmm.
15%. So in
Hmm.
the 90s, I think the threshold for how much you could have give away tax free upon your death, I think
Hmm.
it was 900 grand. I guess I was working with this number not too long ago, but I've forgotten it. But basically, if you had over a certain amount of money, you were taxed a lot upon your death, right? So
Hmm.
there was a lot of pressure in the 90s to ensure that spouses could take advantage of that credit and use it, at their death, so that you could reduce the overall taxes at the second death.
Okay.
So in 2012, there's something the Congress introduced something called portability, which allows a surviving spouse to use the unused decedent spouse's credit. So let's say, for example, um, the first death happened, and then the spouses, they didn't have that much money, right? So all of a sudden,
Hmm.
that decedent spouse's credit, it's still basically unused. Not very much of it's used at all, and they died. Let's say the surviving spouse, the wife, ends up winning the lottery, and
Hmm.
all of a sudden she's wealthy. So upon her death, she can actually use her credit, and then she could use her decedent spouse's credit as well, as
Okay.
long as she basically makes the tax election upon his death, within a certain time period. So that was one introduction that made it so that the pressure to use someone's to split the trust, for example, to kind of
Mhm.
like use the credit, that pressure is
Mhm.
off. And not only
Okay.
that, I think today, if each person could give up to $15 million tax free. So I think that that old school pressure to fashion up the trust in a certain way to split it up, like that's no longer necessary. So if you didn't change that, if you did not keep up with that, if you died today and you had a trust from the 90s, I think you might end up leaving your kids with quite a bit of a mess because of that forced use of the credit or forced split of the trust. So like I said, I think like that's like fairly more technical and definitely
Right.
more boring to talk about. What I'm saying is like there could be a landmine that was
Yeah.
planted in an
Yeah.
old trust that ends up, blowing up in someone's face like later on, decades later on. So that's why it's a
Hence,
good idea to sort
yes.
of keep the conversation going. And
Yeah.
then once you've done it, you kind of do it. So I think I've told people, like having a trust or an estate plan, it's not like a Ronco rotisserie chicken where you just kind of set it and forget it. You actually have to like sort of look at it on occasion and talk about
Right.
it on occasion. Yeah.
What's if somebody's looking for an estate planning attorney where they live, is what are you looking for to ensure that you're working with somebody who knows what they're doing, who knows the intricacies of everything, who's up on the latest, and who's got your best interest at heart? Is there anything? Are there any like red flags that you should stay away from, or this one's
Yeah.
good, or what?
I can give you what I think my clients look for, and I could give you what I personally would want to look for. So I think what my
Okay.
clients often look for is proximity, people who are kind of close. But the
Hmm.
reality is that you could actually work with people from a different state, even. I mean, so long as they're licensed in your home state and
Okay.
that they could accomplish the virtual estate planning as possible. I think with advances in technology, there are a lot of virtual digital estate planners who could
Mhm.
basically serve in all the states that they're licensed in, and that's
Okay.
my case, right?
Are you
Um,
licensed in all states?
no, no, no. I'm licensed
Oh,
in New Mexico and also in California.
okay. Gotcha.
Sorry if I
Okay.
misspoke. Yeah. I think my clients also seem to look for just age and experience. I think one of the things I realized is that until you have things to lose, or if you suffered some loss
Hmm.
yourself,
Hmm.
it's kind of difficult to kind of serve the clients because you would have no basically understanding of what they're going through, right? I think it's
Yeah.
this is a fairly um, for a lot of people, I think it's kind of serious-ish area of law, but
Hmm.
it's also kind of a beautiful area of law too because you're kind of wrapping things up. So I think
Yeah.
like people who are younger may not have that sensitivity or understanding of what the client is going through.
Yeah.
A big one I think my client is looking for is often cost. I think the vast majority of clients want things done as cheaply as possible.
Yeah.
Um, I found that estate planning is fairly price sensitive depending on where you live. So in Los Angeles County, what I've seen is that people on the west side, attorneys on the west side, can charge, maybe like 50% more than people maybe 10 miles inland, which is kind of odd.
Yeah.
I kind of did the numbers in my head. I think maybe people are charging roughly, maybe it works out to being maybe 0.5% of what the real estate value is of the house that they own. It's a really interesting marketplace.
Okay.
Um, so I think oftentimes a lot of clients, if they are really cost sensitive, they would simply go with like a LegalZoom or something online where it's a DIY service. They go to a document preparer, and that might end up being a bad decision if there's no additional legal analysis that's done for them. So
That was going to be one of my questions was
yeah,
with the evolution of things like LegalZoom and now even AI. I mean, I would assume probably some people are test driving GPT on,
a thousand
right in their
percent,
will.
yeah. I mean, I've
Really?
got yeah. I mean, I've got a probate client right now, and she is more computer savvy, and she often tries to send me stuff through ChatGPT, and I have to like kind of sort through things out,
Yeah.
and like I know that she relies on it. I would say maybe 85% of the stuff sounds right, but then again, like if you really dig into it, um, it may be really really wrong too.
Yeah.
Um, so and then I guess for me, if I were to look for an estate planning attorney, I would interview more than one. I
Okay.
feel like when you're working with it, when you're working with an estate planning attorney or any attorney, you are basically looking for a specific profile you can work with. I think like we all kind of do the same thing, and oftentimes all of us do the same type of analysis.
Hmm.
Um, it's not standard, I feel like. So it all comes down to whether or not you can trust the person, whether or not you like the personality, whether or not they are getting back to you on time. I
Yeah.
feel like people are working with avatars, right? So I think if you
Yeah.
want someone who is more into legacy building, you work with that person. If you want someone who works more with who understands more of the death and dying process a lot more, you
Hmm.
could find someone like that as well. Um, but I think the biggest thing is probably client communication. You know, whether or not they get back to you via email or phone, accessibility on time. I think
Yeah.
that's huge.
Yeah.
Whether or not that they're willing to talk with you after the estate plan is done, or are they more of the person who, or are they more of the firm that just does it for you and then kind of just leave you at your own devices after that, right?
Yeah.
I
Yeah.
think it's ideally, if I were to find an attorney, it'd be about relationship building and client building. I think that's the ideal type of attorney I'd want. In
Okay.
terms of costs, I'd say, like when you are hiring an attorney, it's going to cost you anyway. But then again, like I think that difference of a couple $1,000s between attorneys, it's nominal compared to like the end
Right.
result,
Yeah.
in terms of savings and saving yourself from all that stress and headache when
Yeah.
it is time to pass, or when there is a death.
Yeah.
Yeah.
So you have power of attorney, medical power of attorney, executor of the wills, executor of the estates. What are each of these roles, and what advice do you have for people in terms of selecting the right person to be in those roles?
Yeah, it's really interesting. I reflected on what I'm seeing like after like doing the client meetings, and I found that in my client meetings, a lot of people, even though they know a lot of people, they're really successful in what they've done, and they've got a large network.
Hmm.
I've met people who don't have very many people that they could trust,
Yeah.
like really true close friends or family that they would trust with their lives, with their money, and with their kids.
Hmm.
So I think like oftentimes ends up being the surviving spouse. That's number one, and then oftentimes for a lot of families they appoint their children in key positions, like the role of executor, like the role of trustee, like the role of healthcare agent for their own healthcare advance directives.
Hmm.
Um, that's default, right? And oftentimes it goes down in like succession of birth order too. So like
Right.
the oldest child might be the more competent child for finances. If you happen to have a medical person in the family, that's great. They could be the advanced healthcare directive agent. Um, but for the people who have nobody, there are like professionally licensed people who they can serve as trustee, they can serve as executor. Those people are neutral parties, and they just kind of come in and they do that they need to do to follow the trust or to follow the law when it comes to probate. But I think, like, for me personally, as I'm seeing all these people in my client meetings, when I'm seeing like how they struggle, it basically has given me like some motivation to develop these relationships with people, so that my kids could be taken care of, or looked
Yeah.
after. So it's kind of like giving me kind of like a odd little sneak peek as to like my life personally. It's
Yeah.
really fascinating to think about that. So it's been quite the interesting journey when it comes to um, what what it's about when it comes to just relationships. Because at the end of the day, it doesn't matter what the documents say. I mean, if you have um, the relationships intact, people will be willing to help you no matter what. I think that's ultimately what this is. I mean, um, the will, the trust, all that stuff, it's simply ultimately just a reflection or a memorialization of what you talked about, and a memorialization of your network and your friendships and relationships with people. It's a very people related type of practice.
Yeah. What's the number one misconception you think people have or think about when it comes to estate planning?
I could give you two. I think the number one is that they think that you need to have a ton of wealth to justify like any sophisticated estate planning. I think so in the state of California, so long as you have a home, that already warrants you to at least look into it because you want to, because it already to put you in the probate territory, right?
Hmm.
I mean, granted, true wealth is just being alive. Because if I told you, hey, here's $10 million, but the caveat is that you can't wake up tomorrow, you would say, no, I won't take $10 million, right?
Yeah.
Um, the fact that you're alive and well and have friends, you're already wealthy. So that's already argument for getting an estate plan. The second misconception is that people think that trusts are used to protect assets or trusts are used to save on taxes. Based on today's tax laws, that's no longer really a thing. And secondly, what most trusts, how they're written in the country, they don't provide any sort of asset protection. It operates more like a thin layer that allows somebody else to take over. And that function, that operation, allows people to avoid probate. So the analogy that I come up with is imagine that you're on a flight to some faraway place and that flight takes 80 years, right? And you have luggages with you. The three luggages you have are they represent one, your bank account, secondly, your house, and third, your savings account. So on your luggage, you have a name tag that says who it belongs to. If you own assets personally, you literally just write your own name. But if you happen to have a trust, you could put down the name of a generic trustee. So when you don't make it on your flight on your destination, you pass away. Um, when someone shows up at baggage claim, um, and if there's a tag that says the successor trustee, that person could show up at baggage claim and take over for you, right? But if
Hmm.
you have name tags that happen to only have your name on it,
Right.
obviously you've gone, you've passed. So that luggage it stays in baggage claim until they figure out who should it belong to next after.
Mm, yes.
So it's like I
That's
think
a good
it's just
analogy.
yeah, it's like it's a way to let someone else take over to avoid that baggage claim procedure.
Okay. All
Yeah.
right. What have we not touched on that you're like this is truly the most important thing that people need to know about estate planning? Was
Yeah,
there anything that we've missed?
absolutely. I think the advanced healthcare directives
Okay.
are a big one. I think ultimately that document will be used no matter what happens. Everybody, it's not everybody ends up in the hospital, but I think like the vast majority of people do die. They do die in the hospital.
Hmm.
I guess like even if you don't pass in the hospital, your advanced healthcare directive still could apply. But I think for a lot of families, what they struggle with is how do we um, how do we make the decision as to like when is enough?
Hmm.
Do we want life support? Do we want certain pain relief medications? Do we want artificial nutrition or hydration? Right. The answer is also not very clear. It's also not very binary. I think like when the time comes, people who are even really well versed, they can struggle as to how long do you keep the person on a life support machine. Um, One of our friends, really young. I mean, she didn't even make it to 40.
Hmm.
But at the very end of it, it was kind of difficult to decide when to end the life support. I think the gradient is so difficult that no matter what happens, it's just difficult like decision to make. So ideally, in your advanced healthcare directives, you make the binary decision as to whether or not you would be on life support, but you also give the healthcare agent your philosophy on life and quality of life.
Hmm.
If you can let them understand what it means and whether or not you want to be kept alive, I think that that'd be ideal, right?
Hmm. Hmm.
It's just a matter of kind of following the person's wishes as to truly bearing the burden and making the choice yourself.
Hmm.
Um, that TV show on HBO called The Pit. I think there was an episode that illustrates, yeah, that
I saw
illustrates
your
really well.
post on that. It was like, oh, I don't know how the doctor like could even stomach moving forward with.
Yeah, and like so, my wife, she's not in the ER, but she's in on the floor as a hospitalist, so she has to deal with this too. And
Mhm.
family members will try to fight you and
Mm,
try to override what the directive says. If there is one, if there isn't, they would definitely try to override whatever the default rule is. So in some ways, you're playing this like really sophisticated customer service role. I mean, people want something, so you try to give them something. But
right.
then again, at the end of the day, it's like the person who is on the hospital bed, they might have a really difficult time,
Yeah.
and is that living? I really don't know. So I think people have to come with terms of the fact that death is natural; it's part of life, and the
Yeah.
documents that we're doing are death documents. But it also makes it easier for the people around you.
Yeah.
So I think even if you don't do any sophisticated estate planning like a trust, or if you don't even have a will, at the very least, do the advanced directives. They're called different things in different states, but basically the idea is still the same. Number one is you get to appoint the person that you want to speak on your behalf when you
Okay.
can't speak for yourself
Hmm.
because you're incapacitated or you're kind of in and out or you've got a diminished capacity. And number two is you kind of decide what type of medical treatment you want. Like, do you want
Hmm.
full code? Do you not want that? Do you want to put some conditions on it? Um, and to really list your life's philosophy and to have these conversations, these difficult conversations
Hmm.
around how to take care of your body if you do end up at the hospital.
Yeah. Have you are total related but slightly off topic? Are you by chance a Seinfeld fan?
I am not because I don't like it. It's just because I never, had the
Okay.
discipline to really sit through.
There was an
But I've
episode
seen I've seen different episodes for sure throughout my life.
there was an episode where they were lobbing around, oh, these specific questions. Okay, so you can't eat for yourself and you can't, swallow, but you can breathe. Okay, keep me alive. And they just go through all these. It's kind of a funny scene, but anyway.
Yeah, no, it's complicated. I mean,
Yeah,
some of the best advanced directives I've seen, like they've listed the types of TV shows that they want to be put on. They want like animals around them
yeah,
if it's possible. They've
yeah,
listed certain music that they want.
yeah,
They've listed certain drugs that they want. So
yeah.
it's like it definitely does take a lot of insight to make those decisions. I feel like a lot of attorneys do a lot of disservice for clients when they happen to say, "Hey, check this box or check this box," and we're
Yeah,
moving on.
yeah. Okay.
Yeah.
All right. So I ask everybody that I interview the same three questions to wrap up. So, uh, what has been the single most impactful experience you've had since you've been doing this work?
hmm Um, I think when I see an estate plan work the way it does, that made me realize the power of advanced planning and the power of the attorney.
Hmm.
I think that's been quite impactful.
Hmm.
I think another impactful thing is just related to my personal stuff. So my son, he's got epilepsy. He's got severe seizures, and because of what has happened to him since his birth, and to see his development, like it's basically my why, the reason I've got into it in the first place. But
Mm.
I've realized that like it made me really appreciate the fact that hey, if you have to have things that you care about, um, you have to make some extra effort to ensure that
Mhm.
whoever comes in to take care of whoever you care about
Mhm.
has the resources.
Yep. What has the work that you do taught you about living?
That things are really touch and go. It's all about maintenance, maintaining relationships and friendships. Um, things change. Family family dynamics are very complicated, um, and it's one of the reasons why when someone passes, things kind of realign themselves. But I think like it's everything's about maintenance.
Yeah.
You wash your car, you work out, you maintain your relationships. It's the same thing, and it's the
Yep.
same thing with estate planning too.
Okay. Last question. Are you afraid to die? Why or why not?
I feel like I've been leaning into my practice as kind of an odd moat to get
Hmm.
used to the idea of death so that I won't be surprised.
Hmm.
But then again, I feel like I'm also robbing myself of of the, I don't know, delight's not the right word, but the experience of death and dying.
Hmm.
Um, so I want to say that I am not I'm not afraid of dying the same way I would have been when I was younger.
Hmm.
But then again, I feel as though, and I would miss certain things about my life living.
Yeah.
But if I had to give you an answer, um, not really. I'm not
Okay.
really afraid of dying.
Okay.
Yeah.
All right. Will Ha, thank you so much for sharing your expertise with everyone today. And listeners, I will include all of his social handles and website info in the show notes so you can follow him online. Will, thank you again. It has been a pleasure to speak with you today.
Thanks so much, Ashley.
All right. You have a great day.
You too.
All right. Bye bye. If you like this episode of Dying to Know More, be sure to give it a like and don't forget to subscribe so you never miss another episode.